Hi, I'm Maciek Zaremba with Sarasota for Sale over at Keller Williams. And I'm sitting here with
Reid McCullough, founder of McCullough Legal Services.
And today we're going to be talking about the legal obligations by sellers to provide sellers property disclosures. So as I understand it, Reid, by law, by Florida law, a seller must disclose all defects that they know about in terms of, their residential property. Is that right?
That's exactly right, Maciek. Sellers are prohibited from playing hide the ball. They're not allowed to materially withhold information that negatively affects the value of the property on a disclosure. And that's pretty much across the board. They can't say, hey, we didn't know about this defect if they have it, for instance, if they have an inspection or if they have actual knowledge of the defect. The only thing they don't have to disclose, which is kind of common sense, is what they don't actually know about or they had no way of reasonably finding out.
Okay, well now, what about things that they fixed? Let's just say 10 years ago you had a little roof leak and you just replaced the whole roof instead of fixing the roof leak. Is that something that still must be disclosed 10 years later?
Well, that one's a little bit easier because that will actually be revealed in a permit search of the property. You can see that the roof was completely replaced. If there was water damage, that appears on the seller's disclosures. That's something they must disclose because a roof leak is not it doesn't stop at the roof. As you know, water falls down. So a roof leak might also be wall damage, might also be drywall, there might be mold involved. You've got to play your cards face up. And I tell this to everybody, regardless of how long they've owned the property.
Okay, so what about when you're looking at these homes as a buyer and you see this beautiful remodel, all modern, perfect colors, open concept kitchen, and you know it's a house from the 50s or 60s, and then when you take a look at the record, the history of the property, you see that the owner only owned it for about 3 months. So obviously it seems like it's a flipper that bought it. Does a flipper also have to disclose everything? Because oftentimes as an agent, I see seller's property disclosures say just one quick line saying, seller has not lived in this property and therefore is exempt from disclosing.
Well, that's, I don't think that's completely fair because when a seller's only owned a property for 3 months, you know that they've got a recent inspection or that they've been inside the property recently to evaluate it for themselves. So they're going to have a reasonable idea as to what's going on in the property. Obviously, with an older house, you're going to have old house problems, but that does not relieve a seller from the obligation of disclosing what he or she knows.
Okay, so even if I was representing a flipper, it's also very important to tell that flipper that all disclosures are required. And even if they didn't do a single thing in terms of the remodel, they have to disclose everything that they know about the property from day one of ownership to the date of the contract. Is that correct?
Absolutely.
Okay, great. Well, if you have any questions about seller's property disclosures or any questions about real estate, you can give me a call on the real estate. My name is Maciek Zaremba, and I can be reached at 941-888-SOLD.
And for questions about real estate law, feel free to give me a call at 941-484-9714.
Great. Thanks a lot, Reid. Appreciate it.
My pleasure, Maciek. Thanks for having me.